Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, Law Made Simple. Here's your hosts, Sam and Gina Ventola.
Hey everybody, I'm Gina.
And I'm Sam.
And welcome to the Sam the Answer Man podcast, the podcast where you get your legal questions answered by this guy, Sam, our resident answer man. So Sam, could we talk about, we've spent a lot of time talking about, in our Mediation and Practice series, about different applications of mediation, whether it be employment or a partnership dissolving or contract disputes, probate. There are several different types of application, but what are the several different types of actual mediation or conflict resolution?
Well, there are different ways that mediation is done, depending on the context of the mediation or the style of the mediator. So there are a lot of different ways of describing how a mediation might look. You know, one issue is sort of the style of mediation, and really that's going to probably depend on the kind of dispute that it is. So, for example, there's one kind of mediation that's called transformative mediation, and what that is that's mediation where the mediator is focusing on trying to get the parties to see into the other's eyes, to try to get them to agree to make changes that the other people might need. It's really something that's best used for situations where the parties will have some kind of ongoing relationship. For example, family disputes or employment disputes. If there's an employment relationship that both parties would benefit from continuing, if the employee is a valued employee, gives value for being employed, and the employee, the job is something that the employee wants to keep, then both sides have an interest in resolving disputes in a way that, you know, both sides can make changes that the other people can live with in order to preserve the relationship. And that's what we call transformative mediation. And that's, again, something that involves having the parties meet and sort of talk it out and try to find solutions that will benefit both of them. Another type of mediation is called facilitative mediation, and that is where the mediator, you know, basically brings the parties together and tries to help them brainstorming their own solutions. So the mediator doesn't suggest how it might come out, how it should come out. They're like, well, let's think about, you know, ways that we can find to resolve this dispute that you may not have thought of, or that you may not have given serious consideration to. And again, that's focused on, you know, the parties being brought together and talking it out. Then sort of on the opposite end of the spectrum is what's called evaluative mediation. Sometimes it's called muscle mediation. And that is mediation in which the mediator takes a more active role in saying, look, you know, if you do not resolve this dispute through mediation, you're going to have serious problems, and actually may articulate, you know, some of the problems with the legal argument that a person is giving, or with the factual contentions that they're making, whether they're something that are likely to be reasonably adopted by a trier of fact, a judge, or a jury. And so this is mediation that's generally suited to situations where the parties don't have to deal with each other anymore. It's just, you're just trying to come up with the most business way of getting rid of this dispute. And some mediators don't engage in evaluative mediation. They think it's wrong to give legal advice. They think it's wrong for a mediator to express opinions. I don't agree. I think in certain contexts, it's part of what you're paying a mediator for is hopefully having the experience in the law and in the litigation of similar cases to tell you, you know, what you're looking at if you don't get it resolved. And I think that's more helpful in a lot of times cases than just shuffling offers back and forth or just having the parties meet and talk it out.
So with that being said, and my understanding is your style tends to be more of the evaluative. Is that correct?
Usually, again, in like a commercial case or something where there's no need for the parties to sort of live together in the future if you're just trying to resolve this dispute.
So what is another context of mediation, to use your word, the context type of mediation?
Well, so we talked about the issue of whether the parties are together or not. And so one issue you have is, what is the mediation going to look like? And most mediation is in person, but that can be either in person in the sense that everybody is in a room together and they talk and, hear each other out. Or it could be in the sense that it's in person, but the parties are separated. Most mediations that I do, either as a mediator or as a litigator, the parties don't even see each other in the mediation. They're in person, but one side is in one conference room, the other side is another conference room, and the mediator goes back and forth. There's usually not too much need to have the people talk directly. And that again is something that's probably more appropriate for a situation where you're just trying to resolve a dispute and you don't have to preserve a relationship between these people. But sometimes, and some mediators, even in those contexts, will not do that kind of mediation. Some mediators insist that, mediations must occur with everybody looking at each other and talking together, hearing each other out. I guess I don't agree with that in some contexts, but that's the way some people think mediation has to be done, is everybody together talking. Some mediations are not in person. Sometimes they're by phone. For example, if you have a personal injury case and you're bringing a claim against the other driver, and you have a mediation, the other driver is not going to be there because that person doesn't care. Their insurance company is handling the claim for them. And typically, mediators allow insurance carriers not to appear in person. They have the attorney there in person, but they have the mediator available by phone. Or you may have mediations where everybody's just available by phone, including attorneys. Now, that mediation is not ideal in all contexts because sometimes people aren't as committed to the mediation unless they've actually made the effort of showing up and going to a certain place and being there at a certain time. But it is a possibility, especially in contexts where somebody's out of town or, it's not possible for everybody to be together. It's often held some people by phone or even all people by phone. There's also something called e-mediation, which I've not been involved in, but it typically happens in certain consumer contexts where somebody has a complaint against, their cell phone provider or warranty company or something like that. And these companies may have a system set up where they can go onto a website and, type at a mediator in a sort of a chat box, and the mediator will try to quickly resolve a dispute, try to find a solution that the parties can live with. And that again occurs in specific commercial contexts. So that's e-mediation.
So we've talked about transformative, evaluative, and facilitative. And those seem to be mediation styles. Are there other mediation styles where it's just a little different than you guys need to work it out kind of thing?
Yeah, again, it's hard to classify things in a specific way. There's really a spectrum of, telling the people, think about the other person's point of view, or actually telling them, hey, I think you have a serious problem with this argument. And there's no hard and fast classification of different kinds of mediation, but those are the sort of the spectrum of ways that things can get evaluated. And again, it depends on the kind of dispute as to which of those styles is most appropriate.
And what is med-arb versus arb-med?
So there's also different ways of different contexts of disputes according to sort of where the parties are in the process. One is court-appointed, court-ordered mediation, and typically courts, at least in Colorado, will require most cases to be mediated. And the context of that is usually at the end of the case. So lawyers will be given a deadline, you have to mediate by this date, and they'll typically take all that time and they'll wait till the very end of the case and then have the mediation then. And that's court-ordered mediation. It actually is effective because at that point you're staring right into the teeth of a trial and all the expense and inconvenience that a trial implies, and the parties are usually at that point willing to try to resolve the case, mostly because they've incurred a lot of attorney's fees up until now, and that's part of what makes it less valuable to do it in that context. Because if you're doing a court-ordered mediation, again, you're probably doing it at the very end of the case. You've probably incurred a lot of attorney's fees along the way. It probably makes more sense to try to mediate the case early to avoid all those attorney's fees and all the effort that you expended on the case up until then. You asked about med-arb. So sometimes a mediator, normally a mediator does not impose a solution. The mediator only assists the parties in coming to a solution. But sometimes parties will come to a mediator and say, look, we have to get rid of this thing. We need to get rid of it today. So if that happens, the parties can agree that they're going to try to mediate the dispute. But if they fail to do so, and if they fail to come up with a solution that the parties can agree to, then the mediator is going to impose a solution. The mediator then becomes an arbitrator, and the parties have agreed to live by the solution, the binding arbitration of what the mediator suggests. Doesn't happen that often, but that is something that does happen if the parties are very desperate to make sure that the thing is resolved almost immediately. Sort of the reverse of that is arb-med. There are cases where the parties want to have the case arbitrated. They want to have the arbitrator make a decision, but the arbitrator may make that decision, but then before telling the parties what it is, they'll say, look, I've made a decision, but let's see if we can get something that you can work out rather than what I've decided. That's a little bit more questionable. It's not clear, what the parties are saving by doing it that way, but maybe if they feel better about something they agreed to, it's better to do it that way. There's also what's called baseball arbitration. It doesn't usually occur outside the context of baseball, but it's an interesting proposition. The parties will go to the arbitrator and they'll each give a figure for what they think the player should be paid. And the arbitrator has to pick one of those numbers. And so the arbitrator will probably have come up with a number of what the arbitrator thinks is fair. And whoever's number is closest to that is going to be imposed. And the idea here is to get the parties to submit reasonable, realistic proposals, because if somebody's proposal is, in left field, pardon the pun, and somebody's is more close to reality, the one who's more close is going to be the one that's imposed. So it kind of encourages people not to be way out here with their proposals.
Wow, that is a lot of information. So Sam, do you have anything else you'd like to share?
No, other than, if you have a case that you think may be subject to mediation or dispute resolution, it's a good idea to get in early and to give us a call. Now, if you want us to handle a case, we can't evaluate those cases. We can't tell you whether you have a good case, whether you're going to win if you go to court before the mediation. The mediation has to start. So if you contact us for a mediation, we could say, oh, okay, we can do that. We're experiencing those kinds of cases. Let's contact the other side and see if they agree to use us as a mediator. And if so, we'll schedule the mediation, and then we can start evaluating the case. We cannot, start giving, opinions about how strong the parties' positions are before the case, before the mediation takes place. So we do encourage you not to wait till the end, not to wait until just before trial or the court-imposed deadline for mediating the dispute, but to actually get in there early, possibly even before you hire legal counsel, in order to save all of that and just see, can we get this resolved either through mediation or even arbitration that happens very quickly without incurring the expense of a full court case.
Well, thank you, Sam. That was a ton of information. If you'd like to schedule your mediation, go to ventolamediation.com, click on the box that says schedule your mediation, and it pulls up Sam's calendar and you can see what times he has available. And that way you don't waste a lot of time with the phone calls back and forth between you, the mediator, the opposing counsel, you, the mediator. It really does. We've really worked to streamline this process to make it much easier for our clients, because Sam does litigation. We know what it's like to have to schedule with a mediator, and it can be sometimes a little frustrating. So try our online mediation at ventolamediation.com. And if you want to keep up on our podcast, subscribe to our Sam the Answer Man YouTube channel. We're also on Facebook, Twitter, Instagram, and also for the you audio fans, we have Apple Podcast, we have Google Podcast, we are everywhere. So if you have a preferred audio podcast platform and you can't find us there, let me know. Just write to us on our website. Let me see if I can get that taken care of for you. In any event, have a terrific day, and thanks for tuning in.
Thank you for watching and listening.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.